To be charged with possession of child pornography generally require you to actually possess it. Now, in today's day and age, usually these are done by way of a computer. The prosecutor must show beyond a reasonable doubt that you possessed these items on your computer. You visualize them, you saw them, they're on the screen, or they're somehow downloaded on your computer itself. They can charge you either as a misdemeanor, which would serve you up to 1 year in county jail, or they can charge it as a felony, which can expose that defendant to either 16 months in prison, 2 years in prison, or 3 years in prison. Most offenses that our firm generally come up with involve either the client didn't know it was on there. The reason they didn't know is because there was multiple people having access to that computer. We've recently won a case in federal court where the jury returned a verdict of not guilty simply because the jury wasn't convinced beyond a reasonable doubt that he, my client, and only my client, had possession. Other people used this computer. And it was established that there were 4 or 5 other people on the floor where my client lived that used the computer. So it very simply could have been someone else. A third-party culpability was involved in that case, and that jury returned a verdict of not guilty.